Hello, my name is Jonathan Elkins, and this is my presentation on warranty law. Warranties are promises and guarantees made by manufacturers and retailers that they will fix any problem that may arise with their product and that they will stand by it. Warranties in and of themselves explain what they cover, how problems with the product will be corrected if they do arise, how a customer can get their product serviced if the need should arise, and how state laws affect the said warranty, as each state may have laws that differ from the federal regulations. There are two overarching types of warranties, the first being implied warranties. These apply to all products, even those covered by express warranties. This can range anywhere from your food that you eat being fit for consumption at the point of sale, or that the car that you have bought being in good working order off of the lot. This also applies to real estate, in that whenever a landlord signs a lease or that you're about to be sold a house that is going to be in livable condition, the implied warranty makes sure that when you buy a house or even when you're renting, that there is no risk to your health, and that the only problems with the house would be cosmetic and nothing having to do with the actual habitability of the place. Express warranties are the only type of warranty covered by the Magnuson-Moss Warranty Act, and they tend to be more comprehensive, and they are also always in writing. The Magnuson-Moss Warranty Act was introduced by Congress in 1975 in order to structure warranties, because before that time there had been no law really structuring warranties. Corporations were free to do whatever they wished with warranties, and it would tend to be a little bit more complicated. But due to this act, it kind of streamlined the process and made warranties a lot easier to understand and forced corporations to stay true to their word. This act only covers written warranties, as implied warranties varies from product to product and is covered by the Federal Trade Commission. It is intended to protect consumers by making written warranties easier to understand and more transparent, as previous to this act, it was very, very easy for consumers to have a very difficult time in dealing with corporations when it came to warranties, or even corporations not involving warranties at all. The Magnuson-Moss Warranty Act prohibits tie-in sales and other deceptive practices such as lying on warranties or saying things that don't apply. Tie-in sales was a practice used by corporations before this act, where in order to receive the benefits of a warranty on a product such as an oven, you would have to buy a complementary product, such as tires or an oven that they also sold. And after the Magnuson-Moss Warranty Act, this stopped, which was a great boon to consumers in general. It prohibits the modification or disclaiming of implied warranties. This means that no matter how vague or complex the wording is on your express warranty, it cannot violate the implied warranty. So this means that if you were to have a very vague warranty on a toaster, no matter how vague that wording is, the toaster has to still work. No matter what that warranty says or what it covers, the toaster must work, otherwise it is illegal. There are two types of express warranties. These are full and limited. For a warranty to be full, they must comply with the 5 rules on this slide. The first one being that there would be no time limit on the warranty, that there isn't a 30-day warranty, it's just for the life of the product. The second one being that you extend the warranty to any owner of the product, as some limited warranties only extend to the first owner of the product. Say, for instance, you have a car that has a warranty that only applies to the first owner. If he were to sell it to anybody, that warranty would no longer apply to him. The warranty services are free of charge. So if there were to be any problem with the product that was covered under the warranty, the corporation would provide the service free of charge to the consumer. If a repair is impossible or impractical, the corporations will replace the object, or they will refund you the full value. This was a big problem before the Magnuson-Moss Warranty Act, as when a repair on a product wouldn't go a certain way, or a product proved to be totaled, that corporations tend not to stay by their word. But after the enactment of this, they made it to where that corporations had to stick by their warranty, and that they would have to compensate consumers. And the fifth law being that consumers are not required to perform any duty as a prerequisite to receiving service. The only thing that you'll have to do on a full warranty is to notify the corporation that service is needed. And if any one of these is not met, that means that the warranty is limited and not full. Warranties prior to sale. Because of the Warranty Act, both retailers and producers are required to make a warranty of a product available to a consumer before the point of purchase. And this can range anywhere from cars having the warranties on the window in the lot, or from a toaster having a warranty on the box. And this only applies to products that are above $15 in value. If you have a product that is below that measure, it is not required that you see a warranty for it before the point of sale. Door-to-door companies must abide by the same rule. So if you have somebody coming by and selling vacuums door-to-door, they would have to show you a warranty for that product before you buy it, otherwise they are violating the law. And mail-order companies such as JCPenney have to offer you a way to see their warranty before you buy the product. And this can go anywhere from offering to mail you a copy of the warranty, or offering an online link for you to view it as well. Warranty disputes. Sometimes, on occasion, a retailer or company will breach the warranty. And the first thing to do is to contact the retailer. And most of the time, retailers are they're very much able to sort of work with consumers on a small level. They're often able to compensate you in some small way, very often giving you free gift cards or something to kind of sate you. The first thing to really look for before starting a real dispute is to very, very finely read over the warranty to make sure that they are in fact in breach. Because a lot of times disputes are ended very quickly because it's found that the corporation in question was not in breach. Another thing that one can do when starting a dispute is to get in touch with a state or local protection officer. And these are government agents that will look over the warranty dispute and will often be able to resolve it quickly. You can opt for informal litigation with the company, and this is becoming more and more practical due to the fact of the low cost to both the consumer and the company, and the fact that the litigation usually ends in some form of compensation or replacement and not in any real legal situation. There is also the resort of going to a small claims court. For products that are total value is under $750, you can enter the court and have a bit more of a formal litigation. And this is a bit of an uncommon thing to have happen, but it's not impossible. But the last thing that one can do when in the middle of a warranty dispute is to start a lawsuit. The difference between starting a lawsuit and going to small claims court is that a small claims court is more like a formal litigation. It is, of course, a legal process, but it oftentimes puts the consumer at less risk. When starting a lawsuit, there is the very real possibility that you will lose. Because in a small claims court, you're often facing off against, an attorney or a representative of a company. If you are going in for a lawsuit, it tends to bring to bear legal fees, court fees, what have you. And depending on who it is that you are starting a lawsuit against, if it's a small business, it may just be a hired lawyer. But if you're going up against a corporation such as Apple or McDonald's, you may find that you are up against an entire team of legal experts, and that tends to put a consumer at a bit of a disadvantage. So unless it is an absolute wronging, unless it is a very important thing for you to seek justice, lawsuits generally are a last resort. That is the last thing you want to do, and you have to be entirely sure that that is the path that you want to follow. I have my work cited here, and a thing to mention about this is that warranty law is in fact a very complex matter that is rather difficult to boil down to something that is easy to understand for almost anyone that isn't legally educated. But the Federal Trade Commission actually released a document online that sums up warranty law, and it's very comprehensive. It is, in fact, only about 12 to 13 pages, whereas the actual Federal Trade Commission laws on warranties are a bit more extensive and are a bit more difficult to understand. So there was, of course, supplementary research that I've done, but the Federal Trade Commission offered a majority of the resources for this, and it's a very interesting read. But thank you for your time, and this is the conclusion of my presentation.